Uh, Honorable Sri Kanakamedala Ravindra Kumar.
Thank you, sir, for giving this opportunity. Sir, this bill relating to the Tamil Nadu, sir, mere including the certain communities in the ST list giving the status is not sufficient. It is the duty of the government to create infrastructure like drinking water, housing, hygienic conditions, healthcare, education, employment, roads and transport. Sir, the people belonging to the scheduled tribes are subject to discrimination and humiliation. In order to avoid this, to prevent the crime against the scheduled caste and scheduled tribes, Prevention of Atrocities Act Section 21(2) states the identification of the caste of the area where the members of the scheduled caste and scheduled tribes are likely to be subjected to atrocities and adoption of such measures as to ensure the safety for such. The scheduled caste and scheduled tribes has been framed. Rule 3(1) said rule caste duty state government to do de-alienate the identified areas, which is the members of ST vulnerable to being subjected to atrocities and adoption of such necessary measures to ensure their safety. As of now, sir, in Andhra Pradesh, Srikakulam, Kadapa, East Godavari districts have been identified and declared as atrocity-prone area under these rules. Sir, but given the present situation in the state of Andhra Pradesh, the entire area of the ST population is living is not safe. They have to let loose in particular. Sir, provisions of the Panchayati Act enacted in the 1996 to give effect to the inserted in the constitution-wide 73 Amendment Act were made applicable to the scheduled area. The Act specifically states that a state shall not make any law, Part 9 of the Constitution, which is inconsistent with the certain features, including state legislation on the Panchayat, that may be made shall be in consonance with the customary law, social, religious practice and traditional management practices, communities and resources. The Grama Sabha or Grama Panchayat at the appropriate level shall be consulted before making the acquisition of the land of the scheduled area. The development of the projects before resettling, rehabilitation of the persons affected such projects in the scheduled area has to be actually planned and implement that. But the state government is not doing the activities contrary to the above said, which is detrimental to the welfare of the scheduled tribes. Sir, previously granting in Andhra Pradesh, granting permission for projects of private companies in the scheduled areas, leasing out the land in violation of the Land Transfer Act. In the 1970s, the same was set aside by the High Court. Moreover, as per the National Hydro Policy, Power Policy, hydro to private companies also giving without competition. Due to the present government station, this tribal culture is in danger, being destroyed with the stoppage of the hydro projects. And further, in the name of SEZs, assigned lands of tribals have been abolished. If you sell it to, they wanted to sell it to the private companies. Several allegations are also there. He also promised free electricity, 200 units to the tribals. They did not, I'm concluding, sir. They did not give it to anyone except these who were in the tandas. They have stopped opening of their mouths on the promise that of converting tribal tandas and the hamlet of into panchayatis. The state government should immediately withdraw the decision. The tribal culture and their lands should be protected. It cannot be allotted to the bauxite mines or any other hydro projects in tribal tandas.
Thank you. Thank you.
Thank you, sir.
Thank you. Manni Sandosh Kumar P. Not present.